Attorneys of Quantum Legal, including Kristen Williams and Blaine Subrian, have written to Police Commissioner Alistair Govero seeking an independent investigation into the operation of the statutory intelligence framework established under the Strategic Services Agency (SSA) and the Interception of Communications Act (IOTA), which includes the lawfulness of the acquisition, interception, retention, dissemination, and use of intelligence, the discharge of statutory duties by public officials, and the legality of executive decisions affecting the liberty and constitutional rights of their clients. The attorneys are representing murder-accused Rajai Ali and Earl Richards, as well as Canadian blogger Chris Muslist. The attorneys were highly critical of parliamentary oversight, stating that, open quote, Parliament did not leave oversight of intelligence agencies solely to the executive. The statutory reporting obligations imposed under the SSA and the Interception of Communications Act were intended to facilitate parliamentary scrutiny and to ensure that those entrusted with exceptional powers remained accountable to the representatives of the people, close quote. They argued further that the reporting obligations also enable the appropriate parliamentary committee responsible for national security matters to perform its oversight function by examining the administration, operation, and accountability of the national security framework. The attorneys added, open quote, the apparent failure to produce and lay those statutory reports over successive reporting periods has therefore frustrated not only Parliament itself, but also the oversight functions that Parliament deliberately established to guard against the misuse of covert intelligence powers, close quote. This consequentially leads, the attorneys say, to elected representatives, affected citizens, and the public being deprived of the opportunity to determine whether statutory safeguards enacted by Parliament have operated as intended. The bench attorneys said that the matters gave rise to significant public law concerns beyond the question of whether criminal offences have been committed. Open quote, they raise legitimate questions as to whether executive decisions affecting liberty and constitutional rights of our clients were reached in accordance with the principles of natural justice, procedural fairness, and legality, close quote. The attorneys added on this matter of breach of justice and procedural fairness that, open quote, legitimate questions arise as to whether executive decisions founded upon such intelligence were themselves reached through a process consistent with procedural fairness and natural justice, close quote. In light of these concerns raised, the attorneys propose that the Commissioner of Police pursue an investigation to include the following matters: whether any person knowingly withheld, delayed, altered, suppressed, or prevented the submission of reports, whether interception warrants were sought, obtained, or executed in relation to Rajai Ali, Earl Richards, and Christopher Hughes, and if so, whether every requirement of the Interception of Communications Act was complied with, whether intelligence obtained through interception warrants was lawfully disseminated between intelligence agencies, the National Security Council, ministers, the Trinidad and Tobago Police Service, or any public authority, whether any public officer knowingly exercised authority based upon intelligence that had been obtained or managed contrary to the statutory safeguards enacted by Parliament, and whether any records relating to interception warrants, intelligence assessments, National Security Council deliberations, SSA reports, or communications have been destroyed, concealed, altered, or withheld from lawful oversight. Mark Besant, TV6 News.